Thank you, Ian, for a very kind introduction, also for introducing our panel. So we're moving to the meat and potatoes or sandwiches of today's topic. So the influence of ICJ PCIJ judgments on investment law and arbitration from a substantive law perspective. So we'll be looking at the obligations under investment treaties and how PCIJ, ICJ decisions have or have not, or may not influence them, or should not influence them. So we have a very distinguished panel with not less than 4 commentators. So I'll introduce our main speaker and then the commentators all together. We'll start with, of course, a presentation by Professor José Antonio Rivas, who you know, of course, is one of the founders of the World Arbitration Update, Why We Are Here. He's also founding partner of Xtrategy in Washington, D.C., working investment law and arbitration, and is also lecturing at Georgetown Law. Our first commentator will be Dr. Reza Eftekhar, who's a senior legal advisor at the Iran-US Claims Tribunal. He's also practicing in international investment and commercial arbitration, and very importantly, he holds a PhD from Leiden University from 6 years ago. Then we have Dr. Daniel Peat, my dear colleague, assistant professor of international law at the same Grotius Center. He previously worked at the International Court of Justice. Daniel's research focuses on international law, international dispute settlement, international arbitration, including also very interestingly from a behavioral social science perspective. And Daniel is also, together with me, organizing the Master in Dispute Settlement and Arbitration here at Leiden University. Then our third commentator, Dr. Cameron Miles, is a barrister practicing in public international law, commercial arbitration, investment treaty arbitration. He has appeared in before many international courts and tribunals, PCA cases, the International Tribunal for the Law of the Sea, the ICJ, and has also impressive expertise in investment treaty arbitration. And then finally, another dear colleague, Bojana Risitc, who's a PhD candidate here at Leiden University, managing editor of the Leiden Journal of International Law, previously worked at the Permanent Court of Arbitration as a fellow before joining Leiden University, and before that, University of Novi Sad in Serbia. So a very distinguished panel. We'll first give the floor to José Antonio, and then we'll have commentators. Our commentators have a bit of a different approach, so some will offer more substantive insights, others will try to trigger some comments, pose some questions, and then based on that we'll have a debate and hopefully also some questions and answers from the audience. But first of all, I'm happy to give the floor to José Antonio, who will talk about mostly a couple of cases, certainly Iranian assets case, LC case, and the obligation to negotiate access case. We've discussed them already in some parts before. So José Antonio, you have the floor.
Thank you. And can I have the... Oh, no. Thank you, Eric. I mean, it is a real pleasure, as indicated before, to be here in Leiden, in The Hague, at the Leiden University's campus. Just to make it clear, just an anecdote. Some may have almost gotten to Leiden yesterday, but we're all here, so that's a happy event. Now, I would like to share the structure with you.
Nice. You're probably too far from the. Okay, I'll do it. Just nod when I need to.
Wonderful. So the structure that I would like to follow very briefly next is one that basically looks into the structure that I would like to follow very briefly it has 4 main points. One, is there a compelling legal basis or a reason to apply public international law or substantive rules identified by the ICJ case law in investment arbitration. That is the core question. I mean, we may take it for granted somehow. We may consider that it is simply a matter of it's a world court and therefore it should be listened to and applied in investment arbitration. But there is a core issue as to whether this is persuasive, interesting, or somehow compelling. So I think we should address it. I will try to address it very briefly. Then as number two, what are the substantive rules that may be common in investment arbitration and may have somehow been handed by the ICJ or the PCIJ? And finally, do we see that influence specifically in investor-state arbitration cases? So that's the structure, and then by the end, I hope to get to the conclusions. So the first question, I mean, that's a sign of a question. And next, then there's a couple of reasons we can move forward as well. One is investment law is part of public international law. Why do we say this? In great part because as indicated by several investment treaties and also by the ICJ Convention, Article 42. One is the tribunals, investment tribunals under that system are compelled to follow the agreement between the parties, and the agreement between the parties is both composed by the treaty itself, which provide the offer of the state, and by normally the request for arbitration, which include the acceptance by the investor to submit the request for arbitration under the rules of the treaty. So that is part. And if, in addition to that, Article 42 also provides that that in addition, in absence of any clear agreement, also the rules of international law may be applicable. So that's under that system. But there are other reasons why the treaty itself, some treaties are very explicit, like the old NAFTA or NAFTA-like treaties, the DRC CAFTA, or the Peru, Canada, FTA. They're very explicit as to the application of international law. A similar fate has been followed by some bilateral investment treaties. The treaty between Spain and Argentina, cited in the Rivas case, refers to international law. So explicitly, many treaties refer to it. Now, what if it doesn't refer? What if the instrument does not refer explicitly to international law? Even then, the claim is that international law should be applicable because you're ultimately referring to a treaty, which is part of international law, as included in the Article 38 of the ICJ Statute 1A. Now, there are also treaty provisions affirming the application of international law as said before. The examples have already been provided. And in addition to that, there's also a international law, or there are international rules of interpretation, namely Article 31 of the Vienna Convention on the Law of Treaties. And there you can get to the same conclusion both through the application of Article 31 to the context, and you can also get more specifically, which is to me is the most interesting part, because so far we have referred to application of international law through the rules of Article 31(1), mainly the letter of the treaty, the purpose, the context, and all interpreted in good faith. But then Article 31 3D 3C, sorry, refers to there shall be taken into account together with the context, C, any relevant rules of international law applicable in the relations between the parties. And that is a means also to take into account the application of custom to the extent that it's applicable. And general custom would be applicable if you go beyond interstate disputes and you accept that investor arbitration, at least investment treaty arbitration, is part of public international law. So that is the basis, at least in terms of the application of the treaty and custom. But something beyond that also happens, in particular substantive provisions, which is some investment treaties, and namely those that are modeled after the NAFTA model, which refer to the minimum standard of treatment, that has been clarified in the language of the subsequent treaties to the NAFTA, which refers to the minimum standard of treatment following mandatorily the customary international law standard. So by way of reference, those treaties, the DR-CAFTA, some FTAs negotiated by Asian states and in the Americas, they make explicit reference to tying that standard to customary international law. And then the definition in those treaties to customary international law are very close to the definition of Article 31(1) B. And which defines custom general practice plus opinio juris. When you get to that definition, you must tie it to what is understood as custom under public international law, and tie it to the notion of evolution of that practice, and that evolution of that practice can better be identified, although not even the ICJ has the function of saying what is and what is not custom, but they do it similarly to the ILC. They identify some of the rules and are helpful to inform how it evolves. So that is in a fast track manner why this discussion is relevant. Now we go into the next phase, which is some of the ICJ PCIJ decisions that have provided relevant rules that could be considered important by international investment tribunals. And here, although the research can be further expanded to other cases that I mentioned just briefly, the three main cases that I looked into were Electronica Stipula, in the case between the US versus Italy, and then also the certain Iranian assets, as well as the access to the sea in the case of Bolivia versus Chile. So by way of summary, how we do it on time? By way of summary, in expropriation and requisitioning, what we have there is a set of rules that I would like to take a little bit more time on, specifically when we look into expropriation in LC versus in US versus Italy. Just to recall the facts, because I think that is important. That is, as a reminder, a case in which the mayor of Palermo issued an order of requisition of the plant of Elsie, and the reason to do that in part was to protect jobs and the continuation of the services provided by the plant, and those motivations were tied, at least in the understanding of the court, as reasons of grave public necessity and urgency to protect the general economic public interest. That sounds very similar to police powers. First of all, the court or the chamber of the court, but because in that case the court appointed a chamber to decide the case, basically looked into whether or not this case amounted to some level of expropriation, and whether Italy or the mayor had limited the power of managing and disposition of the assets, which is a basic part of the right to property, use and management. And in that particular case, because of the circumstances in which the plant was, in which the company was, it was very close to bankruptcy. The court basically said, well, ultimately you would have gone to bankruptcy anyway. So the possibility of managing and disposing was already affected. So that did not constitute ultimately a violation of the right to manage and dispose of your property, and therefore there was no ultimate expropriation. That is a very fine analysis, which has been considered later. More importantly, if we move forward on that case, the case is mostly known for the standard that it set in on fair and equitable treatment. That standard, I mean, I know that many of you know it, but I'll just emphasize it. Arbitrariness is not so much something opposed to a rule of law as something opposed to the rule of law. It is a willful disregard of due process of law, an act which shocks or at least surprises a sense of juridical propriety. This standard is one set, of course, during the last century, and the question is whether it has had any impact. I won't answer the question yet, but it's coming. So moving along, that standard has also been relied upon concerning full protection and security, and I will stop on LC there, just there. Moving along with the case on certain Iranian assets, that case is, of course, as we have heard it from Professor Attila and also from Professor Touvenin, is a case very relevant for fair and equitable treatment. There, at least in my mind, most impressively, the court, especially on that standard, did a very detailed analysis of the notion of fair and equitable treatment, one, and two, of what the term reasonableness means to interpret the relevant article of the treaty. That is in paragraph 145, where it detailed whether the meaning of the term or reasonableness or fair and equitable treatment, and basically it applied a proportionality test when interpreting the term reasonableness, and whether or not that test comes from ICJ or from European nation relevant law, it's really immaterial, because this is law and it has been applied by the ICJ, and in many investigative arbitration cases it's embraced. Also the notion of what do you need to do when interpreting a term such as reasonable or unreasonable measures. Moving along with that case, I would simply like to conclude that in particular in that case, there was a finding that indeed the measures set out by the US concerning the central bank of Iran were indeed unreasonable, even though they were unreasonable, and the acts were also those that could have amounted to compensatory expropriation, even though on damages the question changed, and that will be, I would expect something to be discussed later in the last session of today's time. Finally, on legitimate expectations, the case that I have looked into is the one between Bolivia and Chile on access to the Pacific Sea. There, I would start by reading the relevant paragraph very briefly. The court concludes that, well, it notes first that the references to legitimate expectations may be found in arbitral awards concerning disputes between a foreign investor and the host state that applied treaty clauses providing for fair and equitable treatment. And this is perhaps the important part. It does not follow from such references that there exists in general international law a principle that would give to an obligation on the basis of what could be considered a legitimate expectation. So ultimately, there's no general rule or general principle in international law that legitimate expectations should be respected, not as custom or not as a general principle. That could be one reading of it. And if you ask, for instance, counsel that would be representing states in investor arbitration, this is a very interesting gift. Well, they could question whether or not legitimate expectation is a sub-rule of fair and equitable treatment. Why? Normally, treaties do not explicitly include legitimate expectations as part of as a subpart of the obligation on fair and equitable treatment. They make some clarifications, such as affecting the investor does not necessarily mean that there has been a breach of legitimate expectations, but there's no explicit reference to it being part of fair and equitable treatment. That could be sort of a gift for counsel, for respondent. But I go back to something that was said this morning by Professor Attila, which is looking at the context of how a case, how the tribunal or the court made its conclusion. And in that case, the ICJ did a very specific work on reading the correspondence between the two countries and reading whether or not there was an intent by Bolivia and by Chile to enter into negotiations. And it concluded many things. It concluded that there was no acquiescence. It concluded that there was no clear evidence that could be provided as proof that the states had an obligation to negotiate the access to the sea. It concluded that there was no estoppel. So after all those elements, it then follows in this rather short paragraph that legitimate expectations is not necessarily a general principle of international law. So without taking that with the context, I think that it would be perhaps too much to simply say that it doesn't exist if you have, for instance, a case where the circumstances are dramatically different. For example, a promise between a state and an investor, or for example, a stability law. So I close with that. The last point, I mean, and the conclusions are in the presentation, and we can talk about that, is whether or not this influence that we have seen and that has indeed been been real to the extent that investor arbitration tribunals cite these rules, electronica sicula, and not thus far the Iran assets tribunal or the Bolivia case, but whether these rules taken together are somehow forming part of an international, public international law slash ICJ jurisprudence constante, taking that not as precedent, but as certain rules that are repeated because they appear to be consistent not only in investor state, but from ICJ. And I conclude with that. Thank you.
Thanks very much, José Antonio, for extensive discussions of these cases. So first commentator is Reza. Yeah, you're free to stand up or stay where you are. Who will, amongst others, talk about the question whether you can actually use ICJ cases, and in respect of the question whether the treaties invoked before the ICJ are basically the same as those applicable in investment arbitration.
So thank you very much, Eric. Good afternoon, everyone. Thank you for being here today. Before anybody forgets, let me make a reference to Casino Austria before anybody forgets that. Everybody has been referring to it since early in the morning. This was actually one of the unseen actors in formulating the ICJ's reasonableness in the context of the expropriation discussion. So I think Hans van Houten would be very happy. I'm sure. The International Court of Justice rendered its judgment in the LC case in 1989. This was a diplomatic protection case that was based on FCN that was concluded between Italy and the United States in 1948. This judgment was rendered before any investment treaty award had been issued. In fact, the first investment treaty award was in 1919, AAPL versus Soyan. In that judgment, the ICJ interpreted various provisions of that FCN, in particular substantive standards of protection incorporated in that treaty. Those clauses closely resembled provisions commonly found in investment treaties. In LC, the community of investor-state dispute vastly relying upon and quoting LC in different respects, in particular on the definition of substantive standards of protection, such as arbitrariness and full protection security. But no similar interpretation of FCN substantive standards was forthcoming for more than 33 years. And that changed when the ICJ rendered its high-profile judgment in certain Iranian assets. This case was also another diplomatic protection case based on an FCN, namely the Treaty of Amity between Iran and the United States that was concluded in 1955. And I would venture to say that had it not been for this recent judgment, we wouldn't be gathered here today for this conference. The community of investment state arbitration has already begun relying upon the ICJ's judgment in that case. And to suit the purposes of world arbitration updated panel, a forum where you, thanks to its wonderful co-founders and the dedicated team, the most recent developments of arbitration are examined every year. So I would rely to two very recent submissions by claimants in two cases that have relied upon the certain Iranian assets judgment rendered by the ICJ. So you see that the reliances have already begun to be made, and we would see them, I think, sooner or later in the actual awards and decisions rendered by investment treaty tribunals. Now, with these preliminary remarks, let me get to the gist of my presentation. And that is, are the judgments of the ICJ based on FCNs distinguishable from an investment treaty context as far as issues of substantive standards of protection are concerned? Of course, any good arbitration practitioner knows very well that there are various grounds on which to distinguish a past award in the current proceedings. But to suit the panel of our, suit the present purposes for our panel of substantive obligations, I want to stay focused on this controlling substantive framework. So the question is whether the judgments of the ICJ based on FCN interpreting the standard protection catered for in these treaties are distinguishable from an investment treaty context where the tribunal owes its jurisdiction to an investment treaty. And why am I doing this? Because among other things, for a past award to have precedential value in the current proceedings, you need similarity. So if all the other conditions are met, among others, you need similarity in the substantive setting. If the substantive setting is similar, sufficiently similar, then in principle, that award or decision can be relied upon in subsequent proceedings in another setting. And I think the practical takeaway of this presentation will be that when relied upon by the parties in the oral or written pleadings, or by arbitrators in the deliberations, would the different treaty framework provide a basis for making this distinction between the judgments of the ICJ and LC and certain Iranian assets and all the other cases that we have heard today? Do they provide a sufficient basis to negate the impact of the ICJ's judgments in investment treaty arbitrations? And to go through this analysis, I propose two-step exercise. Firstly, I go through actually juxtapose the object, purpose, and structure of investment treaties with those of the FCNs. And secondly, I will turn to the specific controlling treaty provisions, and I will compare the two treaty systems. And as you can see, my exercise is focused on international treaty rulemaking. I'm not going to discuss the cases very much. 1 year ago, Jabedian and I wrote an article and we discussed the case thoroughly there. If you want to know my views on the case, so that article has been published in Arbitration International. So the cases are discussed thoroughly and they were very well covered by José Antonio, and I'm sure will be covered by our other esteemed co-panelists. So to the first factor, its object and purpose. Of course, it is unquestionable that FCNs, because of their broader personal and subject matter scope of application, covering all the citizens and also encompassing matters like trade, navigation, and diplomatic cooperation, in comparison to the object and purpose of investment treaties that only focus on protecting the rights and interests of investors and their investments. They do have more broader and wider individual goals. But the bottom line is that both FCNs and investment treaties, they seek the same ultimate goal from an economic perspective. And that is that both seek to foster the economic relations between the contracting parties. And they both seek to protect the economic interests of the citizens of the contracting parties in each other's territories. So, and I think one issue that has to be borne in mind from a temporal perspective is that after the Second World War, one of the key objectives of FCNs was the protection of foreign investment. And both FCNs that we talked about today, the Italy, US FCN, and Iran-US Treaty of Amity, they both squarely fall within that temporal category. So I don't see any meaningful distinguishing factor in terms of the object and purpose. But let me turn to the structure of the two treaties. The main novelty of investment treaties is granting a direct redress to investors to lodge claims against the state on the international law claim. So the investors already benefit from the substantive package catered for in FCNs. What they lacked was the conferral of a direct right to engage the state before an international adjudicatory forum. They had to be piggybacked by their home state. So that their claims had to be enforced, they had to be espoused by the home state. So, but this procedural innovation of investment treaties that was granted to investors in recognition of the substantial financial contribution that they make to the economy of the host state, this union, this really changed the scene, and that, I think, changed the structure of investment treaties, distancing it from FCNs. And it really made the investors the center of gravity of the investment treaty law system. Now, I just leave a question mark. Does the state-centric FCN, when the judgments are based on such a treaty, does it provide a basis to make a distinction between the state-centric and the investor-centric system of investment treaty? And more precisely, the state-to-state model, does it provide a proper distinguishing factor when compared to the investor state dispute settlement model? And this is something that everybody could deny on a theoretical basis, but I think when you engage in cases that involve two estates in comparison with cases that involve an investor and a state, somehow, apparently something at the back of your mind, the responsibility threshold gets heightened. It would be much more difficult to find responsibility when the two parties are states. And there is this theory of indubio mitius. Everybody denies its existence. But if it is at all applicable, does it find more application in state-to-state cases in comparison to investor-state cases? So the question is, does the dispute settlement setting in the two treaty systems somehow have an effect on the threshold of finding responsibility on the part of the respondent state? I just leave a question mark there. Let me turn to the last part of my presentation, and that will be focusing on the specific controlling treaty provisions. And here I'm just using FET as an example, but for good reason, because FET is invoked in like 95% of investment treaty arbitrations, and then investment treaty tribunals find responsibility on the part of the state. 65% of the times they find the breach of the fair and equitable treatment. So that's why I've chosen FET. And the FCNs, there is no doubt that they established a foundation for later formulations in investment treaty arbitrations. I just read the one article from the Treaty of Amity. Each high contracting party shall at all times accord fair and equitable treatment to nationals and companies of the other high contracted party and to the property and enterprises. Now, I want to compare this to the mostly used investment treaties. So, namely to the US-Argentina, which has been used 22 times, and the Netherlands-Venezuela BIT that has been invoked in 20 investment treaty arbitrations. And I want you to compare the formulations. So in the first treaty, it says investments shall at all times be afforded fair and equitable treatment that enjoy full protection of security and shall in no case be accorded treatment less than that required by international law. And the second treaty, each contracting party shall ensure fair and equitable treatment of the investments of nationals of the other contracting party. I do not, of course, there are some linguistic differences, and there are textual variations between the three treaty clauses I just quoted. But you don't see a sufficient factor to make a distinction between these treaty languages. And people speak of FCNs as precursors of investment treaties. Well, as long as what they say, they mean that they came earlier, I agree with that proposition. But if it is meant that they were less sophisticated, more primitive versions of substantive standards of protection, I have to respectfully disagree. Because for decades, there was no substantial change in the formulation. The states that were negotiating investment treaties for decades, they had no reason to change the formulation of substantive standard of protection. Until the baby boom of investor state arbitration, with the first surge that we saw in 2000 and afterwards, then the states started negotiating new bilateral investment treaties, modern bilateral investment treaties, and they started the exercise of modifying their treaties. And I think the first countries that did that were the USA and Canada in 2004. So I don't see a distinguishing factor as long as the old generation BITs are concerned. But what I just said comes with a critical caveat, and that is more modern investment treaties. They treat the standard of protection with greater nuance. While the old investment treaties, old generation investment treaties, they entail unrefined FETS standards. The modern investment treaties have added more refinements, more clarifications, more flexibility mechanisms seeking to safeguard the rights of the states to regulate. I just give you one example from. I had to skip one of my slides because of the that simply explains the stagnant nature of investment treaty rulemaking for decades. It's from Kenneth J. Vanderbilt. I think the text speaks for itself. I just read it out. And it says why the treaties formulations didn't change for a long time. During my years in the Office of the Legal Advisor, because of my work with the US FCN treaties and the US VITs, which included provisions analogous to those in the FCN treaties, I had acquired an understanding of the received wisdom within the State Department concerning the meaning of the various provisions of the FCN treaties. I expected the records to shed new light on the received wisdom, perhaps revealing places where the interpretation of a provision had evolved between 1945, when the first post-war FCN treaty negotiation began in 1982, when I joined the State Department and BIT negotiations were underway. I found instead that the consistency of interpretation dating from 1945 had survived into the 1980s. Even the negotiating strategy for the BITs was largely unchanged from that of the FCN treaty. So that text speaks for itself. But the modern investment treaties, as I said, they have provided for more clarifications on the standards of treatment. And if you refer to Article 2 of the BIT between the UAE and New Zealand, it was concluded in January 2025. In paragraph 2, you see a fairly standard fair and equitable treatment. But if you continue reading paragraph 3, you see so much refinement. A party breaches the obligation of fair and equitable treatment, referenced in paragraph 2, if a measure or series of measures constitutes denial of justice in criminal, civil, or administrative proceedings, fundamental breach of due process in judicial and administrative proceedings, manifest arbitrariness, targeted discrimination, or manifestly wrongful grounds such as gender, race, or religious belief. So you see that there are so many reservations added to the normal interpretation of an FET, and that definitely impacts the influence of the otherwise insightful and useful ICJ jurisprudence in investment treaty arbitrations. And let me conclude by saying that, and here comes the central message of my presentation, is that while there is no distinguishing factor in terms of the controlling substantive framework, as long as the old generation BITs, the situation is different with respect to the modern day investment treaties. But the very, very important point is that so far, 97% of the cases, ISDS cases, have been based on the old generation BITs. And a great majority of 2,500 investment treaties that are in force are also old generation investment treaties. So that means we will expect to see the influence of ICJ judgments based on standards of protection in FTNs on an appreciable number of investor state disputes proceedings. Thank you.
You, Reza. I now turn to Daniel.
Great. I have a few slides.
It's over there.
But thank you, Eric, and thank you for everyone turning up after lunch and for inviting me here today. So what I want to do is I'll give a few shorter comments, and as Eric requested, few substantive insights, and hopefully slightly more comments to trigger some reaction. I'm taking a flexible interpretation to the use of ICJ jurisprudence. Otherwise, as I think we can discuss, there wouldn't be too much to talk about. So I've also understood that to be ICJ procedural law as well. But first, what I thought we'd do is, I thought it'd be interesting to actually contextualize what we're talking about here. And behind me, I have a lovely colored diagram, which obviously is self-evident what it means to everyone. But there's been some interesting empirical work done on the use of ICJ case law within international dispute settlement generally. This is some work done by Damien Charlatan, who analyzed 75,000 citations in dispute resolution tribunals. And so you can see in the middle, we have the pink and red nodes, which are PCIJ and ICJ judgments. And then to the top right, you have yellow nodes, which are ISDS awards. So as you can see, there's some overlap, and that overlap was probably largely addressed in the first panel and in the following panel, but we're going to see what we can make of this. So in total of the 1,568 citations that were included by ISDS tribunals in this analysis, almost half of them were to ICJ cases. Compare that to 46 to WTO panel and appellate body reports. So what are these topics? This is something that empirical evidence doesn't really give as much information about, but some evidence. So this is the same study, a subsection of these cross citations analyzed. And as you can see, the vast majority relate to procedural issues. We have simply expropriation really in the top 10. So when I was racking my brains as to what to talk about with regards to substantive obligations and the interaction with ICJ jurisprudence, two issues popped up. And those are interpretation, which José Antonio has already mentioned, and sources. So I'll, in the rest of my presentation, say a few more words about this. The first is that interpretation is, as we know, and as José Antonio said in his presentation, the rules of the VCLT are taken as being customary. And it's standard practice for ISDS tribunals to cite ICJ jurisprudence as authority for this. Of course, if they're customary, there's no reason that you would necessarily cite the ICJ, but it's the done thing. And here we have an example. So this, this is from the Mohammed Kab versus Turkmenistan award, citing to Legrand as authority for the proposition that Article 31 is customary international law. But why does this affect the substantive obligations under investment law? I thought maybe there are two ways that this could be the case. The first is that if you look at Article 31, the whole idea, as many of you know, of the ILC when they drafted the Vienna Convention provisions was that the text is the authoritative statement of the party's intentions. Therefore, you didn't have to go and look behind the text for what the party's intentions were. This is why we see preparatory work relegated to a subsidiary, supplementary means of interpretation under Article 32. And this idea that the text is the place to focus when you're interpreting, and you don't have to go and look for other manifestations of party intent, is something that has been adopted by ISDS tribunals. Next slide, please. As you can see, this Pin Ang versus Belgium award is authority for this. So it spells it out slightly more explicitly than other tribunals. And the importance of this, I think, is accentuated in the context of ISDS disputes, where clearly the intentions of the treaties, treaty parties, only relates to one of the parties, and therefore they may have access only to one, to certain evidence that is not accessible to the claimant investor. So I think on the one hand, the use of the VLCT provisions and the use of ICJ jurisprudence is important because it promotes this slight focus on textualism. The second reason is because, as José Antonio mentioned before, it brings into play Article 31.3c of the VCLT, which has been used as a gateway to refer to other rules of international law. Next slide, please. So here we have the Philip Morris versus Uruguay Tribunal doing exactly that. Now, in the context of Article 31.3c, ICJ jurisprudence is important because not only the ISDS tribunals rely on ICJ jurisprudence for the proposition that the Article 31 to 33 rules of the VCLT are customary, but also when identifying what the relevant rules of international law are, they almost invariably, if not explicitly, look to Article 38 of the ICJ statute. Again, in principle, there should be no reason why that necessarily is so, but it's something that's done. And here we have an example from Ranco versus Peru, in particular, saying that the rules include general principles of law. That is a nice segue to my second point, which is that the ICJ statute and jurisprudence has been seen by ISDS tribunals as an authoritative statement of what the sources of international law are. Why is this important, and how does this interact with substantive obligations? Well, as you all know, and as we've discussed a little bit already, when we're talking about substantive obligations, FET and legitimate expectations loom large. And the legal basis of legitimate expectations is highly controversial, arguably somewhat flimsy. But on one line of reasoning, and the one that's most often used by tribunals, it's that legitimate expectations are a general principle of law within the meaning of Article 38, 1d of the statute of the ICJ. Next slide, please. And if tribunals don't use that as a way to get legitimate expectations in by virtue of Article 31.3c, they found other ways to do it. A nice example is the Gold Reserve versus Venezuela case, which was under the ICSID additional facility rules, the applicable law of which refers to rules of international law. And there, the Gold Reserve Tribunal said that if you look at general principles of law, which can be induced from domestic legal systems, legitimate expectations exists within a sufficiently wide cross-section of domestic legal systems to constitute a general principle, and therefore we need to read FET in light of that. Now, I think we can have some discussions about how convincing that line of reasoning is, but nevertheless, it requires the ICJ jurisprudence and procedural law in order to be able to make this case. So that's briefly what I wanted to say in terms of my substance. What I wanted to say as well to trigger some responses, a few things. So in relation to José Antonio's presentation, and interpretation in particular, you mentioned Article 31.2 of the VCLT provisions, and you said that that was particularly important. So I'd like to hear a bit more about why you considered that in particular to be important. Reza, I think it was very interesting, in particular that you picked up on these initial uses of certain Iranian assets. But some of the empirical research that's been done on cross-citation notes the the importance of the people that make the decisions. So Nicola Ridi has done some interesting work on the use of ICJ jurisprudence by ISDS tribunals, and he noted that often when ICJ judges could sit as arbitrators, those tribunals were the ones that used ICJ jurisprudence. So my question for you is, now that they cannot sit as arbitrators, do you think this changes? Linking back to the two pleadings that you mentioned, I had a quick look, and interestingly, One of those pleadings, the team of counsel composed of 5, 2 of whom used to work at the ICJ in the past 5 years. And for the Riverside coffee case, one of the members of the tribunal was Philippe Couvreur. And so if you're making an argument to the panel, surely ICJ jurisprudence would go across quite well. So brings me to the larger point of ICJ jurisprudence in terms of substantive obligations. Is it not a matter more of the experience that you have and the arguments that you think are going to fly best with the tribunal, rather than there being any inherent utility to it? With that, I'll leave the presentation.
Thank you, Daniel. Many thanks, Daniel, for adding your comments and also asking some very good questions. Now we turn to Cameron.
Thank you, Eric.
Yeah.
Ladies and gentlemen, it was with great enthusiasm that when it arrived some months ago, I opened Eric's invitation to speak on this august panel dealing with a topic very dear to my heart, namely the cross-fertilization of legal principles between the International Court of Justice and other international courts and tribunals, specifically those tribunals operating within the system, and I use that term loosely, of treaty-based investor-state dispute settlement, or ISDS. On what had I been asked to speak? I wondered idly as I scanned the program. Would it be jurisdiction and other preliminary questions? The role of ICJ jurisprudence in procedural law? Treaty interpretation, treaty termination, attribution defenses? I suppose, I thought, I could handle compensation if Eric puts a gun to my head, contemplating a 30-minute intervention on the various ways one could pronounce Horjol factory. But then I saw my name next to substantive treaty standards, and I began to feel, in the words of the great Tom Lehrer, a bit like a Christian Scientist with appendicitis. And I began to feel that way because of all the potential areas of influence of the ICJ in international law. Its influence over substantive treaty standards in ISDS must surely be amongst the most limited. Performatively, I cried out, as if knowing this episode would provide a useful introduction for these remarks. What had I done to Eric to offend him so? And how could I make amends for what was so obviously an insult sufficiently grievous to put me on the receiving end of this proverbial hospital pass? But then I pulled myself together and I thought again. Not every question has to be answered in the affirmative to be worthwhile. Some of them can be answered in the negative. And through the answer so given, tell us something about the system in which the question is situated. Cross-fertilization, like any process of transference, works better in some contexts than in others. And the question that we have to ask ourselves is why. And so that is what I will be doing today, explaining why, in apparent distinction to the areas of transference being addressed by other panels at this conference, substantive treaty standards seem to provide such poor soil for the concepts promulgated by the ICJ to flourish within the ISDS system. To make that statement good, I might refer to Dan's examination of the empirical data, which shows that really ISDS tribunals don't tend to refer to the jurisprudence of the ICJ when dealing with substantive treaty standards. But I might also add one reductive and anecdotal example of my own, which is the 2024 volume on General International Law in International Investment Law, edited by Andreas Kulik and Michael Weibel. This volume, largely successfully I may add, attempts to explain how international law principles of wider significance may find their way into everyday application by ISDS tribunals. The book contains 46 chapters, only 3 of which can confidently be said to deal with substantive standards. And this is in comparison to 16 chapters on the law of treaties and a further 17 on state responsibility. Plainly, Andreas and Michael, 2 men not being known for being afraid to mine for detail, did not consider there to be yet deeper veins of knowledge for an industrious author to dig out with respect to substantive standards. So in the time remaining to me for this intervention, I'd like to suggest 4 reasons as to why this might be the case. Now, the first one is an obvious one, which is that of regularity of consideration. Although we are all very familiar with investment treaties, or would like to be at any rate, we must understand that these are unusual agreements from the ICJ's perspective. They deal solely with technical questions of foreign investment. They are often expressed in ambiguous pro forma terms like fair and equitable treatment. These terms are then repeated over literally hundreds of treaties with little or no elaboration. And they are almost invoked only by natural or juridical persons who have no standing to appear before the court under Article 34(1) of its statute. While many of them also contain interstate dispute settlement clauses, these are rarely invoked. And on the odd occasion that they are, think cases like Ecuador and the United States or Italy and Cuba, they do not refer the dispute to the court. As a consequence of this, the ICJ lacks a regular opportunity to pronounce on the substantive terms of these treaties. Whilst what it has to say may be of great interest as to how those treaties are to be interpreted and applied, witness its many pronouncements, for example, on the VCLT and the Articles on State Responsibility, it is rarely called upon to do the actual task of interpretation or application itself. Indeed, the court has never been called upon to directly consider what we in this room would consider to be a recognizably modern investment treaty, whether bilateral or multilateral. The most it can hope to consider, as Reza has pointed out, are the forerunners to these bargains, such as the 19th and 20th century US Friendship, Commerce and Navigation treaties, which the US, back when it still believed in international law and the idea of its accountability thereunder, subjected to ICJ jurisdiction. So we see these at play, for example, in the US Nationals and Morocco case of 1952, the Elsi case of 1989, the oil platforms case of 2003, and the certain Iranian assets and alleged violations cases, which are still before the court and have produced meaningful judgments. And we also see their UK equivalents in some cases, so the Anglo-Iranian oil case of 1951 and the Ambertelios case of 1952. A diligent ISDS lawyer, trawling these judgments for reasoning that is readily applicable to the interpretation and application of a modern investment treaty will, I'm afraid, often find him or herself disappointed. Take the MFN clause, for example. True it is, the court in Anglo-Iranian oil may have provided the basic framework for the analysis, requiring identification of 1, the basic treaty containing the MFN clause, and then 2, the third-party treaties under which the benefits are sought. But that is of little assistance where, as the arbitral tribunal in the Ambertelios case pointed out, there is no such thing as the most favoured nation clause, and every treaty requires independent examination. So that's our first problem. The court rarely gets asked the kinds of substantive questions that an ISDS tribunal cares about, and even when it is usually in the context of dated treaty language that does not always reflect the modern style. By way of example, it is not for nothing that of the multitude of tribunals that consider the MFN clause in the old NAFTA Article 1130, none of them referred directly to the ICJ's jurisprudence on MFN as considered in Anglo-Iranian oil, US Nationals in Morocco, and as Jose Antonio has shown, and as Dan has confirmed, the ICJ does tend to do rather better when it's called upon to address points of customary international law that may later find themselves embedded in treaties. I speak here of its jurisprudence on expropriation, not to mention that of its predecessor. So Horjov Factory obviously tells us a lot about expropriation being rendered lawful through payment of compensation. The Oscar Chin case tells us about the kind of rights that can be the subject of expropriation. Barcelona Traction developed the relevant test for de facto or indirect taking. And the Elsi case, the Chamber's conclusion on the eponymous company's status of insolvency prior to the alleged taking, has proved influential in setting out causation as an element of expropriation. But even then, one does wonder if these decisions would have been rendered quite so influential if they hadn't been picked up and incorporated repeatedly into the vast case law of the Iran-US Claims Tribunal, which has, I would suggest, proved far more influential than the ICJ in shaping the substantive jurisprudence of international investment law, particularly as pertains to expropriation. The first problem, the rarity of ICJ pronouncements on matters of substantive interest to ISDS tribunals, is mirrored in the second problem, to which I turn now. As Zach Douglas has pointed out, the development of a coherent corpus of investment law by tribunals has not been a roaring success. On almost every substantive question imaginable, you could probably find 10 authorities for any given proposition. Amongst this clamour, one wonders, rhetorically in my case, What difference could one ICJ authority possibly make, particularly where the substantive question addresses particular treaty language that the court has not had the opportunity to consider, but 100 investment treaty tribunals have, as in the case of the myriad provisions of the Energy Charter Treaty? Another issue that may confront us here is the quality of the ICJ's reasoning where applicable. Now, I have great respect for the court, but particularly in its earlier judgments, and a great many of the matters we are considering here today deal with these earlier judgments, it wasn't exactly known for the quality of its analysis. The court is a collaborative beast with as many as 17 members. This leads to drafting by committee, a process by which detail, the flypaper of disagreement, is progressively sanded back in the search for elusive consensus. Yes, what is left has the satisfaction of majority backing, but it has also been reduced to the kind of smooth and agreeable bromide that is singularly useless above the level of truism. For example, the Elsie case, decided by a chamber of the court, is often cited as one of the great contributions of the ICJ to ISDS through its pronouncement that the national treatment protection will be violated where, quote, the local law, either in its terms or its application, has treated nationals of the complaining state less well than the host state's nationals, end quote. To which I can only say thanks, but I probably could have figured that out for myself. Now, against this, you, and certainly Reza, may well say, but Cameron, you're forgetting the contribution of the court recently in certain Iranian assets, wherein the court set out in rather more detail inter alia the content of the FET and FPS standards. And in particular, it held that the latter standard was limited to the protection of the physical security of assets, picking a side in a long-running debate in the ISDS community, and you'd be right to do so. But again, I have some issues with this. First of all, and as the court has acknowledged, FET is not so limited to physical security, and given the recognized and significant overlap between FET and FPS, one may really question the extent to which this finding is going to move the needle on investor protection in anything other than an academic sense. And second, the court reached this conclusion having been directed to a significant number of ISDS cases, and even for the first time citing one, Saluka and Czech Republic. The question may therefore fairly be asked, who is influencing who in such a case? And this leads me to my third problem, which I have unapologetically stolen from a chapter written by Michael Weibel in a book that Dan edited a decade ago, enabling me to remind him that we are no longer young PhD students with our entire professional lives ahead of us. The problem is interpretive communities that have adopted particularly sociological attitudes to treaty texts, sociological attitudes that, in certain cases, lead to the formal rules on treaty interpretation being treated with little more than lip service. In my submission, the ISDS communities and its myriad coalitions of arbitrators, academics, and professionals is one such community, at least when it comes to some of the substantive standards that this panel is discussing. When one looks at the so-called modern FET standard, with its various limbs of non-arbitrariness, non-discrimination, transparency, reasonableness, protection of legitimate expectations, and all the rest of it, and then one looks at the words fair and equitable treatment on the page of the investment treaty in question, one does tend to wonder how the first emerged from the second. But these have been reiterated time and time again over hundreds of awards. An ICJ judgment, even one as agreeably straightforward and well-reasoned as certain Iranian assets, is also not, I predict, going to move the needle on this. And it is definitely not going to move the needle if the court approaches the question of substantive investment protection standards from a perspective of orthodox treaty interpretation that the ISDS community abandoned long ago in preference to the reflexive and seemingly endless parallel citation of prior awards, preferably by the same arbitrators that are considering the dispute at hand. Within this context, certain Iranian assets is just another footnote, appearing alongside the thousands of other footnotes that burden ISDS parties' pleadings and which haunt the dreams of law firm associates when they are permitted to sleep. We are in the realm of what Filippo referred to earlier as lazy doctrine, and we've seen what a motivated tribunal, such as the tribunal in Casinos Austria and Austria, can do with it. And that is why, in my suicidally confident prediction, the interesting finding of the court in Access to the Ocean, that protection of legitimate expectations does not reflect a wider rule of international law, is going to have no effect at all on ISDS. The finding is too easily sidestepped by tribunals who will say that it's all well and good for the court to decline the existence of the general rule, but what they are doing is interpreting treaty language, and if the protection of legitimate expectations is not part of FET, well, how do you explain all these other prior awards? And one might posit the other question, of course, unspoken in polite society, which is that if the protection of legitimate expectations, being the foundation of many regulatory claims in ISDS, is removed from FET, from where does the ISDS community get its work? As a great Australian Prime Minister, Paul Keating, once said, in a two-horse race, always back self-interest. At least you know it's trying. And this brings me by way of conclusion to the fourth and final point, which is the response to states of all of this. The dominant reply to what states consider to be overbroad treaty interpretation by tribunals has to be to specify in exact detail the content of FET and other standards so as to minimize the interpretive discretion of tribunals. One can look at Article 8.10 of the Canada-EU Comprehensive Economic and Trade Agreement, which defines FET not in 3 words, but over 7 paragraphs. This new approach has the effect of sidelining the ICJ further still from substantive ISDS standards by taking the treaty text even further away from the classic agreements from which the limited substantive jurisprudence of the court on investment treaties descends. The short and general statements that the court has made on reasonableness, etc., in these cases will have little role to play in the interpretation of a multi-paragraph behemoth that has to be read 4 times before its detail becomes clear, and which the court will never be called upon to interpret in its own right. States may, through this responsive drafting, have sought to limit the interpretive discretion of tribunals, but in so doing, they have diminished the relevance of the ICJ to ISDS further still. Sic transit gloria mundi, we may well say. Now, I've been going on for far too long, and so I suppose I will leave it there for now. I hope this contrarian submission has been, if not informative, then at least entertaining. Thank you for your kind attention. And thank you also to some of my students from the Leiden LLM who chose to attend today, even though they are well aware of my inadequacies as a speaker. Thank you.
Many thanks, Cameron, for having accepted the invitation despite not finding the topic interesting. But I think what you said is of course very, very fascinating and very, very good points that you raised. Final speaker and commentator is Bojana Risitc, as I mentioned, the words of Cameron, the young PhD student with the entire life ahead of her. Who will give some comments as well on the presentation. So Bojana, the floor is yours.
Thank you. Thank you also for having me. It is very difficult to be at the end of this panel, very intimidating as well. I initially also envisioned my role slightly different. So my comment raise some very short questions. Also some of the questions. So I initially wanted to talk about and ask one question which is on a more general side and one which is more specifically related to some of the cases that were discussed. Unfortunately for me, the question on the general side was very elaborately answered both by Daniel and Cameron.
Sorry.
So, no. But it is one of the main takeaways also from this topic when I'm thinking about whether ICJ jurisprudence should be taken into account when it comes to interpretation of contents of standards of protection of foreign investors. One question that popped to me is why would that be so? Why, compared to all the other jurisprudence that we have in investor state arbitration, the one which is, yes, not without the flaws, but it's very specialized field which in quality and contents has done so much. Why would someone consider ICJ jurisprudence of expropriation? Why would we go back to the ICJ? Of course, notwithstanding ICJ's high standing as an institution, and of course, notwithstanding the legal basis for why one could do so. But I think that this question, in essence, has been covered by both of you. So this is maybe my main takeaway. But then to go to more specific comment and more specific question. So the court in certain Iranian assets essentially mentioned some of the contents of potential contents of FET, which is protection from denial of justice, protection from unreasonable, or protection from discriminatory measures. The court says that this is not an exhaustive list, but what is very obvious is that the court does not mention legitimate expectations in any way explicitly, which is something that is, yes, highly debatable, but it is something that is very often mentioned in relation to FET. And we also had heard from José Antonio's presentation about Bolivia versus Chile, where the issue of legitimate expectations was briefly touched upon by the court, also in a very vague sense. So my question for José Antonio or anyone else in the panel, or general question, would be how to reconcile this position of the court, or non-position, whatever it is, in certain Iranian assets with its position in Bolivia and Chile, whether based on this, and this is also something that José Antonio raised in his presentation, whether one should infer that legitimate expectations are included or not included within FET in future cases, first of all in the pleadings and then later potentially in decisions. And and this is my maybe final question, which is more broader question on this topic, whether such, well, short and vague statements of ICJ, for example, as in Bolivia versus Chile, whether they create more or less certainty. Well, I would probably help. I'm probably framing this question already with an answer, but perhaps these kinds of statements create more legal uncertainty in the exactly by being so vague and being framed as such and being as such that one can interpret them in different ways, and creates maybe a bit more confusion in the field, which has already been tainted with confusion in the purpose of, yes, referring to the ICJ case law would be exactly opposite, right? So to have a bit more clarity in legal certainty. So
no, thanks very much, Bojana. I think there's common thread also between most of the comments, and I think Daniel, your comment and Reza's comment on the question of the sort of sophistication of treaty drafting and how this might actually affect the future of ICJ, PCIJ, or relevance of PCIJ, ICJ decision in the future is something that's very relevant. And I think your point also on the really practical usefulness of those rather vague statements. Shall we first give the floor to José Antonio, Reza, maybe Daniel, Cameron, Bojana? We'll be even getting questions, but anyone who wants to answer some of the questions asked, and then we'll see if there's some questions for the audience. But I suggest to start with José Antonio, maybe, and then we go to Reza, Daniel, Cameron, and Bojana, if you want to add something also based on the.
Thank you, Eric, and thank you, Daniel and Miles and Bojana for the questions, and Reza also for your perspective. On the question posed by Daniel on why I refer to Article 31(2), I find it very the reference to how to interpret the context I find very, very important, because sometimes very textualist approach, which is absolutely legitimate. I mean, Brouwer would of course say that in his defense for a very rigorous textual approach. Sometimes the very textual approach of the terms, either because they go to even dictionary perspectives or more elaborated legal standards, sometimes are not necessarily reliant on the context in a limited way, you know, looking at annexes or looking at other terms of the very treaty, but also on the context that may come from instruments of international law, as Article 31(2) indicates, that are accepted by the other party as an instrument related to the treaty, a mere instrument related to the treaty, such as a letter by the negotiating parties, etc., may be extremely relevant. So that is why I make reference to that. Now, on I must say that with Miles' perspective, I do think that he has a point concerning the lack of regularity and specialization by the ICJ on investor-state arbitrations, and that is, I wouldn't call it a weakness. I would simply say that it's not within the realm of its functions, because there is an investor arbitration system, so they are simply unable to develop their perspective, and we can see that a little bit in the access to the Pacific Sea case, where I would dare saying that they were not at all thinking about investments. It's a case unrelated to investment, and yet they provide that reference to legitimate expectations not being a general principle of international law. I would dare saying that they didn't have that in their mind when they drafted that paragraph, I believe 162, maybe wrong on that. But nevertheless, they provide that statement, which is general, which indicates that there is no such a thing as legitimate expectations as a general rule. And then I disagree with Miles in the sense that the counsel for respondents in investor arbitration, they will embrace that paragraph and they will say, no, that doesn't exist. And I see, some of the colleagues here nodding, say, yes, I'm going to use it, right? But now, and going back to Bojana, how to reconcile both? The answer, I think, it somehow has been built by what I said. One is not necessarily investor-state or even at all related to sanctions, which is the Iran assets case, and the other one, and the access to the sea case is definitely related to that. In the access to the Iranian assets case, I do think that the court thought it through, and it made a conscious decision not to include legitimate expectations, and I also don't think that the case will end up in simply, it's not regular enough. But tribunals in investor arbitration may look further, because legitimate expectations, some counsel for respondents may argue that, as Daniel has put it, it is a jurisprudential creation. So what do you do when the World Court says, no, it doesn't exist? They will take advantage of that. I mean, as to how they will go or not, it's interesting. And ultimately, just to confirm, this is case law of the ICJ of today, not Sorsal, that is likely to have an influence, because parties will bring it up.
Thank you. Yeah, very briefly, because we're running a bit out of time.
Very quickly. The question about access to the Pacific Ocean, it's not about parties using it. I mean, parties will use whatever they can get their hands on if they think it advances their client's case. The question is, what are tribunals going to do with it? And the tribunals will say, thank you very much for this isolated opinion from a court that has not considered the question that's in front of us, not considering the treaty that's in front of us. We find it's all very interesting, but terribly ultimately irrelevant. That will be the result, I predict. And what will end up happening is that, of course, respondents will keep raising it, and then eventually tribunals will keep ignoring it. And the end result of this is going to be eventually they'll stop raising it and the argument will die out. That's what I predict, at any rate. The second point was responding to one of Bojana's questions, which I thought was a good one, which is about the vagaries of ICJ pronouncements. And the only thing to say here is that if you stand for everything, you stand for nothing. And what you end up seeing is these few elusive pronouncements of the ICJ being latched onto by claimants and respondents alike, and saying, well, this can stand for either proposition, and therefore giving the gloss of legitimacy to either side, in which case it's not particularly influential at all, except as another parallel citation.
Thanks, Cameron. Reza?
Yeah, shall I go on with the comments first? I will address Daniel's question with respect to the continuous reliance on ICJ judgments in ISDS, considering the ban on the double hatting. And that doesn't, of course, prohibit them from dealing with their ongoing cases, and correct me if I'm wrong on that. But more important than that, there are three more factors. Of course, one of them is the legal assistance. People who have been in ICJ, they would be involved in the delegations of the parties, also involved in the tribunals as arbitrators or assistants. So they would continue to bring this dialogue to ISDS. And of course, the parties' pleadings will refer to the ICJ judgments when it favors their position. For instance, and I will get to Cameron in that respect, with respect to the interpretation of reasonableness, they would get to that point. It's favorable to states because it provides a heightened threshold for states. But let me give you an interesting extra reason, and that's the previous ICJ judges who are involved in investor-state arbitrations. And you can see that vividly in so many cases. For instance, in Mobile, the second versus Canada, the resubmitted case. One of the former ICJ judges who was an erstwhile member of the court up until 2016, he was involved in the hearing of the case. So he was the one who brought up the res judicata effect of a recently issued ICJ case. He raised it to the parties and asked the parties for their opinion to comment on that, so they are not taken by surprise. So this is also another factor that will contribute. And if you read the eventual award, that you will see how it plays out in the eventual award. He raised it himself, and then the parties relied upon it, and it was dealt in the award. And to Cameron, I'm very happy that you made all these points. I should say that you made a compelling dissenting opinion to all of us. But there are points that I agree with you, like the less relevance of ICJ judgments with respect to modern day treaties. You raised some examples. And I think that was also my point. They would be less impactful in those with respect to disputes based on those treaties. But there are also other areas that I have to respectfully disagree, because first of all, I never said that the LC judgment is a great contribution with respect to national treatment. I never even mentioned that.
Oh no, I didn't attribute that to you.
Oh,
no, I know you didn't say that.
Yeah. But you should bear in the view that the judgment came in 1989. There was no interpretation prior to that, and that was with respect to at least FPS and arbitrariness. That was useful for investment treaty tribunals that came after that. And with regard to certain Iranian assets, I would say there are contributions that matter and the contributions that do not matter. And many of these, for instance, the ICJ said that, FET is not limited to minimum standard of treatment. That's already the great majority investment treaty cases. That's not a meaningful contribution. No. But there is meaningful contribution when you get to the definition of reasonableness. And this is a point that I have to further discuss with José Antonio. Of course, we don't have time anymore, but we will continue discussing it separately. With respect to the difference between the ICJ three-pronged test in comparison to the proportionality test, I think that's where there is meaningful contribution by this ICJ. And there is a very interesting phrase in Yannick Professor Radi's book regarding the interpretation of FET, and he refers to substantive indeterminacy regarding FET. And I think we have wasted our time for decades on legitimate expectation. We should have gone from the very beginning. We should focus on the notion of reasonableness as the core key of the FET standard. And here I think the ICJ made a substantial contribution. There are many cases in the context of ECT, many cases in the context of the BITs that start as of 2006 to delineate the concept of reasonableness. And somehow it comes close to a point of maturity by 2023. And really the ICJ is giving it an extra layer of sophistication. And I think this is specific contribution because we are talking about substantive obligations. I'm not going to talk about jurisdictional admissibility, but this specific one is one example of a contribution that really, in my view, matters.
Thank you, Reza. We're running out of time. I don't know if Daniel, Bojana, you want to add something?
That's fine.
So I'm afraid we'll have to stop here. I'm very sorry that we don't have time for questions, but I think probably the questions you had were similar to those that were addressed by our panelists. I hope so. In any case, if you have any questions, we have a coffee break now. But before going to coffee, I want to thank our speaker, José Antonio, for the presentation. Of course, our commentators, especially Hague-based ones, but of course Cameron and José Antonio for having come to The Hague to participate in this panel. So many thanks, and any questions can be addressed during the coffee break.